Hello everyone, welcome back to the Channel 4 special on wills, trusts, and more. I'm Ron Jankowski and I have Eileen Kerlin Walsh here. Eileen is an attorney here in the local area of Palos Heights, but she actually has an office at I think it's 11301 Harlem Avenue, which is actually Worth.
Perfect.
And thank you. And Eileen is here to talk about, as we probably mentioned, you may have caught the first show, about all the legalities of protecting yourself and financially and for the future, and many other things, trusts, and how you should prepare yourself for maybe your wishes to be followed through after you're gone. So we're going to start out today, and I have a list of things that I want to share with Eileen and ask questions on planning for your own lifetime as part of your estate plan. Can you explain?
What does that mean?
Exactly.
Okay, estate planning, this wonderful term estate planning that we use, can really be divided into two major phases. One, planning for your lifetime while you're still here. The other phase is for planning after your death. And it's the lifetime planning, that very important phase for my clients, that we take every bit as seriously as the planning for after death that we're going to talk about today.
Okay, good. First question was, what do you mean by lifetime planning, and what are the issues involved with lifetime planning itself?
What we need to think about for during our lifetime are how we're going to get taken care of ourselves, who's going to take care of us when we are unable to take care of ourselves, but while we are still here. Mm-hmm. So to thoroughly examine that, we need to look at guardianship, the process of guardianship, what that means, why that's important in this phase, and very importantly, how we can plan to avoid it. And how we do that is powers of attorney for healthcare and finance. We're going to talk about those important documents in a little more detail. Another phase of lifetime planning is end-of-life instructions, and we'll take a little look at that also.
Okay. Also, you're going to talk about how we can avoid guardianship as well.
Yes. And
what are there any other lifetime planning considerations that should be taken in when you're planning this?
Absolutely. We'll talk about everything that might be important for lifetime planning. The guardianship, it's important to know quite a little bit about it so we know why we don't want to have it as part of our future. We're going to talk about those very important powers of attorney. Then we'll talk about end-of-life instructions, which includes the living will. And then we'll talk about how we let our family know what documents we have in place, where to find them, when to give those documents to the family, etc.
Okay, I'm going to let you proceed with it.
Let's start with guardianship. Guardianship is the living side of probate, and we talked about this a little bit last time, Ron. Everybody knows about probate. Everybody sees it as an evil, sometimes a necessary evil, but we certainly do try to avoid probate both before death and after death. Everyone is familiar with the after-death probate, that process where the will or the estate goes through the courts. But there's also a living side of that. Same judges sitting in the 18th floor of the Daly Center, because most of us in the Palos Heights community and surrounding cities are in Cook County. So Cook County, 18th floor, Daly Center, those probate judges also preside over guardianship. When do we need a guardian? If there is a phase in our life where we are no longer able to take care of our own finances or our own healthcare decisions, we need someone to step in and do that for us. Mm-hmm. If we don't take some steps to avoid that, then we are going to have to apply to the courts for a guardian. Typically, it is the guardian who applies because they've discovered at the hospital, they've discovered at the bank that they cannot take care of mom, that they cannot sign the documents for their sister, that now suddenly everything has come to a screeching halt when that person needs help the most, when they've had an accident or an illness. Mm-hmm. So the guardian would have to apply. There's a lot of cost involved, there's a lot of fees, there are expenses of an attorney. Not only does the guardian have to get their own attorney to navigate through the process, the court is going to appoint an additional attorney for the ward to look out for them. Courts do not take away your ability to make your own decisions lightly. So doctors have to be involved. They have to determine that this person is unable to take care of themselves. The court will appoint an attorney for that person to go visit with them, write a report, make sure that no one is trying to take away that person's financial power if they still are able to do it themselves. Sometimes they're contested, they can be difficult. Usually it's a successful process. It is lengthy, it is expensive, sometimes necessary, but one of the things that we can avoid with this wonderful estate planning. And what we do to avoid it, there's a couple of ways, but the one we're going to talk about today are getting in place powers of attorney.
Okay, before we go into that and all the other things that you just mentioned, when things go through, and the state goes through a probate process, has there been in the past where the courts would say we're going to freeze the estate because of a reason, or there's a concern, or maybe I'm not using the right words, but has the courts ever done that?
Before death or after,
After death.
Well,
there's an estate and it's in probate and it gets frozen for some reason. The courts freeze everything.
the assets automatically freeze themselves upon someone's death if there isn't a trust with a trustee who can act. So if our assets are in our own name and we've passed away, nothing can be done without probate unless there are trusts. Again, a beautiful subject we're going to cover in a following show. But the assets get frozen. The banks are not going to allow someone, even if you have a power of attorney beforehand, the banks are simply not going to permit someone else now to stay active in that account. So probate is the process whereby those in a will are given the authority by the court to go ahead and take care of everything. So we have full control of our assets during our lifetime. That's taken very seriously. If that control needs to be taken away for our own good because we're no longer capacitated, the probate courts will preside over it in our lifetime. After death, the probate courts make sure all that money goes to whom it is intended to go to, either by the law or by the will. Letters of office. Anyone who's ever had to go through this probate process understands the frustration of going to a bank and being told, oh, you need letters of office. And it sounds so simple, and in fact it's a one-page document. But to get those letters of office, a probate has to be opened. So yes, the bank, the assets almost freeze themselves upon someone's death.
Okay, that answers my question.
And sometimes within a probate there are contests, or there are requests for formal proofs. There can be things, or a non-supervised administration is forced into supervision by an interested party. So those things can happen within the process.
Now, if someone were to contest it, what is the process for that? Not the contesting part, but what do you have to prove? How does it go through the courts again?
Yes. In order for someone to contest a will, so if we're going to assume the will is already going through probate, someone has been disinherited, someone is very, very unhappy. So the first thing they're going to do if they decide to get involved is to get an attorney, request a formal proof of the will. Then the witnesses that signed that original will be subpoenaed, will come to court, and it'll be determined whether the will was properly executed. And those witnesses will say, at that time, we believe the testator to be of sound mind and memory. That's not a terribly high bar to pass. What those who wish to contest a will often do after the formal proof will be to maybe bring an action saying that even if that person was there, competent, and did that, maybe they were under undue influence, or someone, or some kind of a constraint, or a family member that they lived with. But a properly executed will is not easily set aside, is not easily contested. And we attorneys, when we're drawing up wills, know exactly what that family member, who may be for some reason being disinherited, is going to do. So we take all the necessary steps and put in place all the necessary safeguards to make sure that if that's our client's intention, we believe them to be competent, that their intentions are going to be honored and have full legal effect.
Good explanation. Thank you.
Thank you.
I'll let you continue.
Okay, so let's now get back to those powers of attorney.
Yes.
We're avoiding lifetime guardianship. This is all about lifetime. I love my clients. They come to me, Ron, as I've said to you before, often only concerned about their family and how their assets are going to pass to them. But I want to take care of them. So I consider this lifetime phase every bit as important. How are we going to make sure if our clients are leaving town even temporarily, or if they have an illness, or if they get to that end of life phase where they're no longer capacitated or able to make their own decisions, that those people that they choose get to step right in with full legal authority to make all their medical and financial decisions for them. And it's with these simple documents. I am passionate about these documents because they're so inexpensive. Sometimes estate planning can seem like a lot to think about. Even though it's a relatively small investment, for some people, because of the economy, it's hard right now to sit down and invest in something that they see as being for the future. So what I love about these powers of attorney is that even if you're going to do your estate planning incrementally, these are inexpensive. We can get these in place now. So what are these magic documents? You get to choose an agent. It's called your principal agent and your successor agents. There's one for healthcare. In the healthcare, you think now, if I do become incapacitated, who do I want talking to the doctors and the nurses and the pharmacists? If you're lucky enough to be in a marriage, it's often the spouse. If you're lucky enough to have healthy, competent adult children in your life, often you will name them in the order that you think they will be able to make these decisions. And it's not always the same child for both healthcare and finance. Often there is, I have to say this, it's often the daughters who sometimes the parents choose to be by their side. Maybe there's somebody in the family in the medical field whom would have a really good head when a difficult traumatic situation is in place to be able to make the healthcare decisions. Someone else might be the one with the good financial head, who's always been good with figures, who's always been good with money. They might be the one named for the financial power. So we think about who we want and in what order. These agents do have to be named singly, successively. So oftentimes parents who want to name all their children maybe as co-executors, as co-trustees, are going to want this burden they feel shared. But when it comes to power of attorney, for very good reason, the agents have to be named to act alone and successively. It does not mean that the children can't all work together with mom and dad's decisions. But if there's a disagreement, and often there is, we have one agent with full authority to make the medical decision. If we don't have that, we may as well not have had the document should a disagreement arise. We're in the hospital, we need a surgery, there's been an accident, there is an illness. We cannot then be going to the court to decide which of these children's decision or wishes we're going to honor. So those documents name the agent. That can be a difficult decision. And if there is something you want to think about before you get to your estate plan, it's often those agents. Who are we going to name as trustees? Who are we going to name as executors? And for powers of attorney, who are we going to name as the agents and in what order? There's a couple other decisions we can make in the healthcare, though getting someone in place with authority that now does not have to go to the probate courts, does not have to go to guardianship, because you, by making this decision, are saying now, I want, when I am no longer able to make this decision myself, this person to have full authority to step into my shoes and make my decision for me. There's no need to go to the courts. Simple little document, take an hour of your time to think about and get executed, can avoid all the expense, the cost, the difficulty, the ongoing nature of guardianship. At least with death-related probate, 6-9 months and we're done. With guardianship, for as long as the ward lives, that person who has been appointed every single year goes into that court, brings forth an accounting, brings forth a budget. If they have made a change from last year's budget, that has to be accounted for, every single haircut. Now, why do we have such strict rules in place? Obviously necessary. Obviously there is elder abuse. Obviously there is financial abuse sometimes. So the courts are very, very strict when they are in charge to make sure whomever is managing the ward's assets is doing a good job of it and accounting and only acting for the ward's best interests. But If we already know that we have a family member who's going to do that, let's avoid all that invasive, expensive process and give them the authority they need right now.
Right. And before we go on any further, what is the age group that should be planning this and thinking about this and executing these kinds of documents?
Well, I recommend estate planning at any age. Powers of attorney, again, because they're so inexpensive, are easy to get in place at any time. Husband and wives, again, if we're lucky enough to be in that situation, you name someone, get those successor agents, and put them away. You don't have to think about them again. None of us know what's going to happen.
Right.
Any of us, and I'm by no means a fearmonger, but illness is just not associated with old age, and incapacity is just not associated with old age. There are things that can happen to us at any stage in our life. So at any point, especially if you have children and you know that you're going to want all the affairs taken care of if something does happen to you. So it's a really good idea to get it done at any time. As we are going to talk about a little bit later, when you give these documents to your family, or what safeguards you put in place within the documents, might be determined by the age and stage at which you're writing them.
Okay, yeah. Because you might have grandchildren that you want to particularly make sure their education is properly taken care of and covered and so on. So those are things that you should be doing well in advance.
Yes, and we're going to talk a lot more about that when we talk about wills and trusts, when we are planning for the second phase of estate planning, which is after death.
Okay. Any other final things you want to bring up?
Well, another thing that I take very seriously when we're doing this lifetime planning phase is end-of-life instructions. It's something we don't necessarily want to give too much thought while we're robust and vital and healthy and still got so much we want to do. But there's no point in having a desire or a wish for how your end-of-life treatment is, getting it into your will, because then it is too late. And it used to be that people would put in their will whether or not they wanted to be kept alive by machines or things like that. And it was determined eventually that was not the best place for it. Families don't go looking for those wills and trusts, or certainly wills, until the remains have been disposed of, until we've had a funeral or what have you. So we want to get in place, if we have specific end-of-life instructions, we want to make sure our family know about it. So I consider part of this lifetime planning. Within that power of attorney for healthcare that we talked about, you can make a decision there to what extent you want your agent to keep you alive. If you know that you do not want death delaying procedures, we can get it in there. We can also give it its own individual legal effect in a document called a living will. And often, if you already know you don't want those procedures, you want to make sure that document goes alongside the power of attorney. And indeed, for many of you who've even gone in for a simple surgery in your 30s, you may have very well have been asked by the hospital staff, do you have a living will? Do you have a power of attorney for health care? I believe legally they're bound now
to ask you those questions.
Those questions. So a living will, big consideration. As we have mentioned before, you don't have to, I don't say that everyone has to have that living will. This is very much determined by your own personal wishes and desires. Many of my clients do not want to be kept alive by machines way past the point at which they would have naturally died.
But you have to have that document.
If you have to have that document. Now, if you've indicated in your healthcare power to your agent you do not want to be kept alive that way, they have the authority to have it withdrawn. But let me tell you, and I've talked to many people in the healthcare industry, this is not something that's a decision that doctors easily make. Sometimes an ethics committee is pulled together. It depends on whether the family agree. If all the rest of the family agree with this one person who has the agency, then it may very well just happen naturally, not easily. This is never going to be easy. But what we hope to do is take away some of the trauma and difficulty by at least not having a paperwork nightmare. Therefore, the living will, along with power of attorney for healthcare, can make that decision as paperwork-free and as unfrustrating as possible.
If one of your clients or to be a client were to walk in your office and say, I want to prepare all these documents that you just mentioned now, what's the process? How long is involved? Does it depend on obviously what their estate consists of? I mean, all these documents can be done within weeks?
Oh, absolutely. I'll tell you what's the average. What we're talking about today specifically, these lifetime documents, that's a very simple process. We often, if we're just doing this phase, now I have to admit clients will often do everything together. But if we're just doing powers of attorney, maybe somebody is going out of the country or someone is going into the hospital and that has triggered the need,
Yes.
they can be turned around in days.
Okay.
When it comes to the entire estate plan, I would say an average is about 2 weeks. When a client comes, we give them a lot to think about. We may need some documents, but often not. Then if we have a trust, we're going to talk a little bit more about trust at another occasion. It's a two-phase process also, the creation of the trust and then what we call the funding. And the funding can take several weeks, but I handhold throughout. We do the funding as a collaboration and we make sure it gets done. But ultimately, from a client visits me to we have executed their document, I would say 2 weeks is an average. So it's certainly not a lengthy process, especially when we've done our thinking beforehand. And that's what I would hope the education of what we're doing now is give you the ideas that need to be thought about. And it's not really about your assets and where they're located as much as who would I want to act. I have to say, this might be one of the most difficult things for my clients is determining their executors, the order, not wanting to hurt or offend anyone, whom they would trust to be trustees. Young couples thinking about who the guardian of their children would be. Is it going to be somebody on mom's side or dad's side if something should happen to them? Those agencies, healthcare, finance, that's a lot of players we're putting in place. And it can be difficult for someone who doesn't want to make a difference. It's also harder for those in life who don't necessarily have grown, competent children. Sometimes they have to think about who they can trust. And there are even agencies we have that we can appoint as professional powers of attorney for healthcare and finance if someone finds that they do not have those trusted people to put in place.
Well, I'm sure if one were to walk in your office and present their case, you probably have a checklist of things that they would have to provide you to put this all together.
Oh, that's a terrific point. We absolutely have both a financial and a personal fact finder. Maybe that's something we could discuss at a future show. What kinds of questions we're going to be asking. Because when the clients know the kinds of questions we're going to be asking, oftentimes it takes some of the anxiety out of the process, as well as when we talked about the length of time. If you already know where those insurance policies are, if you already know what order you're going to name your agents, your trustees in, those are the things that can take time and certainly do make the process a little fast. I'm never that concerned with getting this done quickly. When clients are ready and we start the process, I will take as long as they need. And sometimes we are dealing, as we have said before, with intimate, sometimes difficult issues. And if it does take a few weeks, if it takes more than one consultation to get to the right estate plan, you know, that's something that we're more than happy to accommodate. It's serious. This is a serious business. It's an intimate business. It's a necessary one. And we find that we will work at the pace that the client needs.
And I get not only what you've said, but it's intense as well for either the couple or the person that's going to have to do all this. I really think a checklist, if we're going to have this coming up in the future, probably would be good for them. They could do a lot of homework before they walk in your office.
Terrific
be
idea.
Better prepared and probably cut down the length of time to process this whole thing.
And take some of the anxiety out of it, absolutely.
Yeah. Anything that you want to add before we close?
Maybe a couple things. When clients do put together those powers of attorney, they'll often say to me, what do I do with this now? Do I give it directly to my daughter, whom I've named?
Where do you store it?
Yes, where do you store it? And I often say it really, you know, the answer to that will depend on the client and their age and stage, where they're at in the process and whom they have in their life, who they've named. what the level of trust is. If you are in advanced years and your daughter or your son is already helping you with a lot of things, it's probably a good idea to give them copies of the document. Or if you're not at that stage, do talk to your family. Let them know where everything is. I'm not a fan of the safe deposit box, certainly not for the lifetime documents, because we may have a problem with access when we need the documents most. I often say a safe place in the home that a trusted family member can access if the need arises.
Boy, what you've just said is a mouthful, because a lot of people, that's where they put all their documents, in the trust, in the box, in the bank. And if you can't have access to it, or the family member that wants to do whatever needs to be done, have access to that box to pull these documents out, now more time is going to be lost.
Absolutely.
And it makes it that much more complicated. Not that they couldn't get access to it, but there is a process for the bank as well.
And what
before
if it's
you even
midnight
start.
and Saturday night?
Yeah.
You know, there's the time issue, even if you've put the child on. And one of the things you'll hear me say over and over is that I'm not also a fan of putting children's names on things in order to make things easier. We have so many sophisticated tools where we can, with a lot of what we talked about today, get the trusted people's names in documents that they are going to be able to help if it's needed. Putting the children on the safety deposit box, putting them on the accounts, putting them on the title to the home, I don't like. I understand that people have done it for years. It can work, but it's fraught with difficulty and possible pitfalls, and we can do so much better. And that's what we've discussed so far and what we're going to discuss in the coming months.
Well
Ron.
said. Thank you.
Thank you.
Well said. Okay, are we at a close for today?
I think so. My final word is, when do we do this? Now, when we're youngest, healthiest, and most important, fully competent.
Okay, that answers my question about age, when you should be doing this. Yeah. Well, very good.
Thank
well,
you,
for
Ron.
those, you're welcome. For those viewers that do want to get in contact with Eileen, I do have some information for you, and we're going to put it at the bottom of the screen. She is located at 11301 Harlem Avenue in Worth. Her phone number is at the bottom of the screen also, 708-448-5169. And the reason that we're giving you all this information is that if you find that we did not cover a topic that you're interested in right now and you need answers, please give Eileen a call. She'll guide you through the thing, and you can make your decision accordingly after you've talked to her. Thank you, Eileen.
Thanks
We will
again,
see you at the
Ron.
next show.
Until
And
next
for-
time.
And for the viewers, myself, Ron Jankowski, and Eileen will be back in about a month, and we'll have more information for you to consider for your planning purposes on your estate. Thank you.